Today, we are pulling back the curtain on one of the most critical, high-stakes moments in any legal battle, the deposition. And trust me, this isn't just some boring, stuffy legal procedure. It's a strategic hunt for the truth, where entire cases can be won or lost long before anyone ever steps foot in a courtroom.
So here's the big question, right? If the trial is the final showdown, how on earth do lawyers figure out what the other side knows? How do they predict what a witness is going to say and expose all the weaknesses in their story beforehand? Well, the answer is the deposition.
So what is a deposition, really? Well, think of it like a super high-stakes interview. It's all done under oath, which means you have to tell the truth, and every single word is recorded by a court reporter. It's this tightly controlled environment designed for one thing and one thing only, to pull the truth out of a witness even when they're under immense pressure.
But honestly, just calling it an interview doesn't even begin to cover it. A deposition is way more than that. It's a powerful, strategic tool. It's a truth extraction machine. You see, it's not just about asking questions, it's about systematically building up your own case while you're taking apart your opponent's.
It really all comes down to these four main goals. First up, you discover information. Finding hidden facts, documents, maybe even other witnesses you had no idea existed. Second, you preserve testimony. This is huge. You lock a witness into one specific story so they can't just change it later at trial. Third, you evaluate the witness themselves. Are they credible? Are they likable? Do they get angry easily? And finally, you get to pressure test your own case and see if it actually holds up. Now, if a deposition is a battle, and trust me, it is, then the preparation is where you win the war. A lawyer who walks into a deposition unprepared isn't just at a disadvantage. They're walking straight into an ambush. And get this, for every single hour a lawyer spends in the deposition, they'll spend anywhere from 3 to 10 hours getting ready for it. Think about that for a second. For a full-day, 7-hour deposition, that could mean up to 70 hours of prep work. That's almost 2 full weeks of work. Why? Because the one detail that wins the case is often buried deep in some document that everyone else overlooked.
So what does all that prep look like? It means building what's basically a master binder, an entire arsenal for the case. We are talking every single email, every text message, police reports, financial records, even social media screenshots, the whole shebang. It's about becoming a complete master of the entire universe of that case file.
Because see, the goal isn't just to know the facts, it's to master them. A truly prepared lawyer knows the case so intimately, so inside and out, that there's no answer a witness could give that would ever be a total surprise. They've already thought through all the angles.
Okay, so the prep work is done. Now it's showtime. Once you're in that room, it all comes down to the art of the question. And lawyers have a whole toolkit of different questioning techniques they use to control the witness, control the story, and get exactly the information they need.
So let's break down 2 of the most basic tools in their kit. On one hand, you have open-ended questions. Tell me what happened. The goal here is simple. Get the witness talking. Get their version of the story out in the open. But on the other hand, you've got leading questions, which are the complete opposite. They basically have the answer baked right in, like you didn't call for help, correct. These are perfect for pinning down one specific fact, especially when you're dealing with a difficult witness.
Now, a lot of times, lawyers will combine these questioning styles into this really clever strategy called the funnel technique. You start out super broad and general. Tell me about the events. Then, based on what they say, you start to narrow it down, focusing on a key detail. You said you left at 8 p.m. And finally, boom, laser focus. You go in for that critical, pin-you-to-the-wall question that forces an admission. It's a step-by-step process of drilling down to the core truth.
Okay, that all sounds great, right? But what happens when the witness just won't play ball? They try to dodge, they try to deflect, they do everything they can to avoid giving you a straight answer. What then? All right, let's play this out. Picture it. The lawyer asks a super simple, direct yes or no question. Did you read the agreement before you signed it? And then you get this, the classic non-answer answer. The witness gives this long story that sounds like an answer, but notice what they did. They never actually said yes or no. They're just trying to cloud the issue.
The lawyer's response to this is so simple, but it is incredibly powerful. They don't get flustered, they don't argue, they just calmly state with total control, "That didn't answer my question. I will ask it again." That move immediately puts them back in charge and forces the witness right back into that corner. There's really no way out.
Now, all of this can build towards the most cinematic, most dramatic moment in any deposition. I like to call it
the evidence showdown. This is the moment where a witness's sworn testimony, their story, gets slammed right up against cold, hard evidence that proves they're not telling the truth.
Pay close attention to how the lawyer sets this up. This is a trap, pure and simple. They aren't just asking a question, they are locking in the lie. They make the witness commit, on the record, to a statement they know is false. So, to be absolutely clear, this is your sworn testimony today, correct?
This whole move is called impeachment, and it is absolutely devastating. It's a three-step knockout punch. Step 1, lock in the lie, which we just saw. Step 2, show the evidence. This is when the lawyer casually slides a document or a text message or even a video across the table. And step 3, confirm the contradiction. The lawyer then forces the witness to admit that what they just swore to is the exact opposite of what the evidence shows. It just destroys their credibility.
And let me tell you, a moment like that is pure gold for a trial. Being able to play that video clip or read that transcript back to a jury, it's massive. A good impeachment doesn't just poke a hole in one part of their story, it can make a jury doubt every single thing that witness has said. It can literally change the outcome of the entire case.
So okay, the deposition wraps up, all the questions are asked, everyone goes home. Is it over? Not even close. In fact, this is where a lot of the real strategic work begins.
That deposition transcript sends these ripples through the entire case. It's used to adjust your trial strategy, it exposes weaknesses you never even knew you had, and it gives you those perfect little sound bites for a jury. But maybe most importantly, it creates huge leverage to settle the case. I mean, when the other side sees a video of their star witness getting completely discredited, you can bet their desire to make a deal suddenly goes way, way up.
And then, right at the very end, a smart lawyer will use what are called cleanup questions. Think of this as the final checkmate. By asking things like, "Are your answers today complete and accurate?" Or, "Is there anything important you haven't told us?" They close off every possible escape route. It prevents the witness from suddenly remembering new information later on. It boxes them in completely.
So you see, a deposition is so much more than just a Q&A. It's an intense, strategic battleground where preparation, technique, and cold, hard evidence all collide. Which really leaves us with one final thought. In a game where the ultimate prize is the truth, what's all that painstaking preparation really worth? Well, as we've seen, it might just be worth everything.